The legislative relations between the center and the state is explained in this video. While we are studying the center-state relations, we have to first understand why there is a need for a harmony or a nexus or a coordination between the center and the state. The prime reason is that India is a federal state, that is, powers are divided between the center and the states, and this federalism is one of the main features of our Indian constitution. Hence, our constitution always tries to ensure that there is a clear division of power between the center and the state in different fields such as the legislative, executive, and financial. Remember, as per our Indian federalism, the judicial powers are not divided. Hence, we have an integrated judiciary or an independent judiciary. Now we can move to the main topic, that is the center-state relations or the division of powers, and it is given under three heads, that is legislative, executive or the administrative, and financial. I already said there is no division of powers in the judiciary. We have a Supreme Court whose jurisdiction is extended to the whole territory. These are the three heads under which the powers are divided in terms of lawmaking, implementation of laws, and the financial, that is revenue or expenditure. Part 11 and 12 of the Indian Constitution contains the provisions relating to the legislative relations between the center and the states. Articles 245 to 255 of the Constitution deals with legislative relations, and the legislative relations are explained under four heads. First one is the territorial extent of central and state legislation. It means how the lawmaking powers are divided between the center and the states. We know for the entire union or the territory of India, we have the parliament, which is the prime lawmaking body. And for all states, we have state legislatures for lawmaking purpose. Remember, the parliament can only make extraterritorial legislations, which means the laws made by the parliament are applicable to Indian citizens and their property in any part of the world. Moving to the next category of legislative relations, that is the distribution of legislative subjects. For the purpose of lawmaking, various subjects are given in the Constitution, and these subjects are classified into three lists, that is union list, state list, and concurrent list. Here the parliament alone is empowered to make laws that are listed in the union list, and this includes defense, banking, foreign affairs, etc. Presently there are 100 subjects in the union list, and all the subjects are of national importance. Similarly, the state legislature alone can make laws that are enumerated in the state list, and these subjects have local or state importance, and it includes public order, police, agriculture, irrigation, etc. And remember, when there is a conflict between the union list and the state list, always the union list prevails over the state list. And with regard to the concurrent list, both the center and state can frame laws which are enumerated in the concurrent list, and it has subjects which has common interest both to the center and the state, and it includes education, forest, marriage, adoption, succession, etc. Now the concurrent list has 52 subjects. Earlier it was 47. After the 42nd amendment, certain subjects were transferred from the state list to the concurrent list, which includes education and forest. This means now both the center and the state has the power to make laws in relation to these subjects. When a conflict arises, the concurrent list prevails over the state list. This scheme of distribution between the center and the state is maintained in normal circumstances or normal times. Apart from the normal circumstances, the situations may arise where this scheme of distribution can be modified or can be suspended, and the parliament is empowered to pass laws in state subjects also. And it comes under the head parliamentary legislation in state field, where the parliament is empowered to make laws under the state list in 5 extraordinary circumstances. And these circumstances include: first one, in national interest; second, during president's rule; Third is during national emergency. Fourth one, as per the request of the state. And last one is international agreements. Now we have to know how the parliament is making laws in national interest. It can be done only when a resolution is passed by the Rajya Sabha through a two-thirds majority and the resolution remains in force for 1 year, but it can be renewed any number of times, and the laws which were passed by the parliament under the state list does not exist beyond 6 months after the expiration of the resolution. Also remember, there is no restriction on the state legislature to pass laws on the same subject matter. The second circumstance is President's rule, when the parliament is empowered to make laws under state subjects. First of all, we have to know what is President's rule. President's rule refers to the rule where the state government is suspended and the central government takes direct control of the state. To know more about President's rule, do check in the description box for the link. Now, when the President's rule is imposed in a state, the parliament is empowered to make laws for that state and it remains in force even after President's rule. Remember, such laws which are made by the parliament under the state list can be repealed or altered or even reenacted by the state legislature later. Now, under the circumstance of national emergency, when an emergency situation is in operation, the parliament is empowered to make laws under state list and it expires after 6 months when the emergency ceases to be in operation. The next situation when the parliament pass laws under state list is when 2 or more state legislatures request for the same. This happens when the states surrenders their power entirely to the parliament in certain subjects. And this is usually done through a resolution which is passed by 2 or more state legislatures. And the laws which are enacted by the parliament are applicable only to these legislatures and not to other states. Remember, these laws can be amended or repealed only by the parliament and not by the state legislatures. And the last one, in order to implement the international agreements or conventions or any of the treaties, the parliament is empowered to make laws on any state subject. This is usually done by the central government to fulfill its international obligations or commitments. For example, this includes TRIPS Agreement, Anti-Hijacking Act 1960, various environmental laws, etc. Now the fourth heading under the legislative relations, which is the center's control over state legislation. Here the constitution gives power to the center to have control over the state legislatures in certain legislative matters. And these matters include when some bills are passed by the state legislature, it is reserved by the governor for the president's assent. And here in the case of these bills, the president enjoys absolute veto power for the approval of the laws made by the state. Also, in the case of certain bills which are enumerated in the state list, the previous sanction of the president is needed. The third circumstance is during a financial emergency when the president asks the states to reserve certain bills and other financial bills for his consideration.